Welcome to People vs. David, a Bessa case, already sizzling with tension. Right from the start, we see a defendant frustrated, an attorney ready to fight within the rules, and overlapping cases that complicate everything. Discovery, preliminary examinations, and now a second case on the same complainant create legal fireworks. The client explodes, accusing the attorney of not fighting for him, while she insists she is but strategically within the law. This clash of expectation versus reality sets the stage for high-stakes courtroom drama. Stay tuned, because every ruling, motion, and emotional outburst will be dissected.
Other side.
Oh, right. Well, I'll just start. We've been here previously. I thought we were coming for preliminary examination and relayed that to my client. He has discovery, but in the meantime, he got a second case on the same complainant. That has caused this to be converted, in my opinion, to be
A second case on
the same, calling from the jail. Allegedly, everything's allegedly.
oh, the
Calling
witness,
from the jail.
right? Okay, he picked up
Everything's alleged.
right.
So that caused a second case, and in my opinion, a second PCC. So we want a preliminary examination for everything. The people have advised me that they will go forward with or without the witness. I explained all this to my client. He exploded. So
What?
exploded. Well, so I didn't know what I was doing.
Okay.
So, and not fighting for him. And that bothers me more. They can tell me I don't know what I'm doing. That annoys me. But when they say I'm not fighting for them, that goes to my core, since I come from a fighting family and I fight for everybody.
Oh, you do.
No, that just is making me talk to you. I am going to fight, but I got to fight within the rules. And I feel I know them a little bit better.
The tension rises as the attorney explains her approach. The client feels unheard, frustrated by the complex legal process. Fighting in court isn't just emotion, it's strategic. Here, the forfeiture motion is discussed, which could allow the case to proceed even if the victim doesn't testify. This isn't just legal drama, it's deeply human. The clash between personalities, expectations, and courtroom rules keeps the courtroom electric. Audience question: if you were in this client's shoes, how much would frustration color your judgment of your attorney?
Counsel, I'm just trying to figure out, he told you weren't fighting for him?
Oh, for sure. And a lot more too.
Okay.
Yes, that's why I want to just express myself.
No, yeah, that's fine. You know, it's kind of funny to me when defendants sit up there, they're in custody, they find themselves in more trouble because you were trying to set this, you were fighting for them, you were fighting at me a little bit with this thing, and then has the nerve to say to you, you're not fighting for him, when the reality is, at least allegedly, he's doing the stupid thing that's making your job harder. So that's fine. That's the way he wants to look at it. And the other thing is, and it just amazes me with some defendants, they come up here, they complain about their attorney, and they don't even realize the jewel that they may have representing them, and also don't realize, you know, that fight is it wasn't quite anything you did. It's just in your blood.
Thank you.
It is your heritage.
I was carrying.
He doesn't understand that. He doesn't understand that you got to play by certain rules. He just wants to do it his way. So if he wants to do it his way, we'll do it his way. It's not going to turn out real well. So what do you wish for me to do, Ms. Ford?
I'm asking that we set this for a preliminary examination, that you hear from the prosecutor and my client understand that I am really putting forth a top effort. And along with fighting, I actually have skill. So I hope that he understands that.
Well, he also needs to understand that there's going to be a motion for them to proceed by forfeiture, I'm presuming. And that's going to make your case whatever it is. And I know your counsel will be ready to go forward. I know the prosecutor will be ready to go forth. But you understand that, Mr. Abs?
I understand everything.
Okay. Then let's set.
Right.
Correct. So
Just to the court's.
He has discovery on the first one.
on the first case, but not on the
Yes.
second case.
Correct.
How many, there were phone calls, so how many phone calls are we talking about? Because he's gonna have to see all of that, go through it all, so I want to make sure he has time, so we're not hearing a complaint about that.
As long as possible, within reason.
Yes.
It has to be reasonable.
You didn't have to explain that when I asked you what they going on without the victim.
Oh, excuse me. Let me put this on the record. I did explain that I guess it's hard to understand the various exceptions to hearsay and how in certain.
Here's where legal complexity meets courtroom drama. The judge breaks down hearsay, exceptions, excited utterances, present sense impressions, and statements reflecting a mental state which can allow testimony even if the victim isn't present. Then comes the motion to proceed by forfeiture. If the defendant's alleged behavior prevents the victim from testifying, the prosecution may move forward regardless. This preserves the case while balancing defendant's rights. The audience thought, should alleged misconduct allow a case to continue without a key witness? This is courtroom strategy at its finest.
How in certain instances they can go forward without the victim. I was trying to explain, and then the people gave me a case I haven't read, but I was trying to give him the site People versus Only 327 Mishap 319. Will the court please explain to my clients certain instances where they can go forward without the victim? Excited utterance, mental state.
There are exceptions to the hearsay rule. Given that this is a domestic violence case, there's a statute which would apply, which would allow them to proceed with police testimony. Also, and I don't know if this is the people's intent, they would file a motion to proceed by forfeiture, meaning that because of, the simple way of putting this, because of your wrongdoing, the alleged victim is not present. So the people would, in that instance, not be punished by what is your behavior, or at least allegedly your behavior, Mr. Epps, and so would be allowed to proceed. That's kind of a nutshell version. I mean, there are a little bit more technicalities to it, but I think that
one of the technicalities would be MCL 768.27C, and as I indicated, that case, People versus Only 327 Mishap 319, and the various exceptions to the hearsay rule. That might be excited utterance, present sense impression, mental state of mind.
Yeah, I mean, it's all of that kind of thing.
Do I got a right to cross-examine my accuser?
You know what? Here's the thing, sir. That, if you're talking about the right to confrontation, there's a statute particularly on point where that may be forfeited because of what is alleged to be your behavior. That was the last thing that I brought up.
What do you mean by that, sir?
I am not here to give a law school class, although I could. I'm not, I know, but I'm just saying that is very technical. That's why you have an attorney.
But I couldn't explain it anymore, and that's why I brought it up.
You just broke down law school for her. How am I different?
I didn't break down law school.
Okay, I'll tell you.
He asked the question.
We have told you.
All right, I'm done. I'm going to set it for exam.
I'm going to go to the jail today, so I will. I'll tell you.
Preliminary examination in this matter, because the people may have a motion. I'll set it for September 17th, 2020.
Okay, just one moment, please. Just, yeah, don't turn your back on it, please.
September 17th, 2024.
Yeah, but he might be if you like.
9 a.m. That's before me.
Thank you.
When?
September 17th at 9 a.m. Oh, wait a minute, excuse me.
Why so long?
That's
3 weeks.
Yeah, September 17th, I can do that, but not the 8th, because that's the judge's calendar. And I'm going to defer the professional. There are some parameters, and you are not being. Oh, that's the new thing in the jail I'm learning, that I'm being.
And I would anticipate the people's motion, so we'll try to hear that.
It's the new buzzword in this world, and everything is a violation of that.
Of what?
Speedy trial. That is the new buzzword in the.
Can I ask a question? What is about what's going on in the jail? Speedy. None of this particular about my case.
You just said you had a right to
like
speedy
this.
trial.
I didn't say. I asked why so long. I didn't say nothing about.
It's not a violation of speedy
trial. I asked
trial.
why so long. I didn't say nothing about no speedy trial. Like
this scene highlights pure courtroom tension. The defendant repeatedly asks about speedy trial rights, but the attorney clarifies it's only relevant to the current case. Miscommunication fuels frustration, motion clashes with procedure. The attorney must manage emotions while keeping focus on evidence and legal rights. It's a delicate balancing act, and the audience sees firsthand how misunderstanding procedure can intensify conflict. Engagement question. Have you ever witnessed frustration with a process make someone seem unreasonable, even when their concerns were legitimate?
Like, Judge Simpson, this is where we're having a conflict at, sir. I'm asking about my case, and it's everything other than the case. I don't want to talk about nothing but this case.
Okay, but Mr. Epps, slow down. You have two things now which have, hold on. You asked me a question, but you're operating off of a premise that isn't going to work. So here's the thing. You had the one case come up. We then had the hearing. There were allegations made, and this is where the complication comes in. There are allegations that are then made that there is phone contact and other communication. I don't know for sure. The allegations have been made. There's evidence of the phone calls. So that's where we are. What the problem then that happens is that leads to additional charges, which then not only is there now this additional felony, that clearly will have an impact upon what the first case that you came. That's what counsel's trying to get through. She's got to get that information. That then leads to other things.
Okay, I understand that. She's not explaining that, sir. That was simple things to understand.
I accept.
Okay.
We're good.
I can't get in between every counsel and attorney and defendant.
Thank you.
And I'm not trying to do that. I'm just trying to explain the process. And I've got to, Mr. Epps, I've got to be fair to both sides. So I got to have it worked out. You would have had an exam before now, had this not come up. Okay, so that's the reason for the stretch out in time.
Okay.
Also, the other thing, so that you just understand, it's not anybody trying to delay anything.
The attorney now emphasizes preparation and fairness. The defendant must have access to discovery, including phone records, and sufficient time to review them. This is more than protocol, it's protection for the defendant. Jail procedures add tension, limiting access to legal counsel. This moment highlights how logistics, procedure, and rights intersect. Audience reflection. How would you balance strict legal timelines with ensuring a defendant fully understands and can respond to evidence?
Because of the allegations that come with that, and sort of this complicated thing, I won't say it's complicated, but it's a thing where they're going to proceed, presumably, and I don't know, they know this for sure, without the witness. Your counsel has to try to do some things. I've got to give her time to do that for your protection.
Okay.
So it's not trying to stretch anything out. I'm just trying to make sure everybody has an opportunity to do what it is they need to do. It's really as simple as that.
Thank you.
Can I say one more thing, sir? On my last court hearing that I will be able to get a hold to her when y'all took my phone.
Excuse me?
At my last court hearing, y'all took my phone. Y'all told me I'll be able to get a hold to her. I'm not able to get a hold to her.
You should be able to call your attorney.
We've talked.
I'm not able to get a hold to you.
I don't.
But we talked.
He's
saying he had to go in the three-way, but we talked.
I'm not able to call her, sir.
You should be able to contact your attorney.
I'm not able to, sir.
Then somebody at the jail make sure that can happen. Ms. Ford, check into that if you.
All right.
To wrap up, People versus David Abb shows overlapping cases, discovery challenges, and the potential for motions to proceed by forfeiture, all while the defendant navigates frustration and his attorney fights strategically. Preliminary examination dates are set, emphasizing fairness, preparation, and procedure. This case is a masterclass in balancing rights, process, and courtroom drama. If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.